Good afternoon, everybody. It's time for our year in review and some predictions about the year ahead and what we're going to be doing. A lot of this presentation today is going to kind of build on what we talked about in September, because I do think that's the big deal in workers' comp law for the next year or so, particularly the fraud stuff that we've been talking about. So that's what we're going to be chatting about today. So we have people joining us, we have clients joining us, and we have other people joining us today as well. So that's going to be some fun. So today I'm going to talk about what happened this year in New York workers' compensation law. And then I'm going to talk a little bit about how the firm is going to serve our clients next year, what we're going to do next year, what's going to be a little bit different, what we're going to be working on together as a group. So case law and trends. How did we drive cases this year? What was different? What happened? Look, what didn't change? Our vision, our mission, our values. I gotta lift it up a little higher. Okay, how about this? Can you see my face now? Yeah? All right. I wore my glasses today. I was told I look smarter when I wear them. All right, our firm vision, great practice, great life. That's not changing. I'm gonna build on that today. But our mission, what is the thing we do? We take control of these New York work comp cases. We're not just watching the claimant go down their happy little rowboats down the river of money and benefits while they pretend to be injured, hiding from work, right? Our job is to stand on the sidelines and chuck those grenades into their rowboat to create chaos and jeopardy in those cases so they come to us and want to settle their cases. That's what our job is to do here. So how do we do that? Well, the answer is we look at every case the same way. We try to bring some creativity to these cases. We try to do new things, challenge the claimant to actually prove their case, right, to demonstrate things. I want us to always be thinking out of the box. That's our job. We've got to bring creative solutions to our clients. If we just sit on the sidelines and do it the way everybody does it, we're going to lose, right? The whole deck is stacked against us. We're the underdog in this story. We have to try new and wild and sometimes things that don't work, and that's okay. I met with a client a few weeks ago and I told him about our case in which the claimant alleged that he developed PTSD. And he said he developed PTSD because he went to work, he was working as a school teacher, and he saw two students engaged in a fight. And it was traumatic for him, and he didn't want to go back to work anymore. He developed PTSD and a stress disorder, and he couldn't go back to work because of the PTSD. And of course, he had a medical expert that said his PTSD was work-related and he was totally and permanently disabled. And of course, we had an expert who said, no, he's fine. This is a made-up story. The case didn't settle until we subpoenaed his Netflix account. I issued a subpoena and I said, I want your Netflix passwords. I want to see if you watch any violent TV shows or any programs that have any violence in them. It made the other side jump. They have opposing counsel, so that's ridiculous. You can't subpoena that. It brought the case to a head. We ultimately resolved or settled the case, right? You're not going to find that in a rule book. You're not going to find case law about subpoenaing somebody's Netflix passwords. That's something that we have to do creatively to move these cases forward. So first thing is creativity. Second thing is advocacy. We're not just here to not lose. Am I standing in front of the screen so you can't see it over there? Sorry. We're not just here to not lose. We got to try to win, right? We have to try to win. We have to try to bring the fight. The boundary on all of that creativity and the boundary on that aggressiveness in court is got to be professionalism, right? There are some rules of ethics that we're always going to be integrous towards. And the last thing is service. We're here to serve others. I'm here to serve you as your leader, and we're here to serve our clients. Without our clients, we're really not doing anything at all. We're just scholars, we're academics, we're law school professors, right? That's not fun. Nobody wants to do that. What's unique about us is that we talk about our wins all the time. I've been really getting very belligerent on social media. I've been writing mean comments on other firms that are posting about how many super lawyers they have in their law firms. And I'm like, that's cute. Show me your wins. You're not a super lawyer if you don't have a lot of wins. And we've been showing people a lot of our wins this year. In fact, we posted 47 wins this year from our legal teams that are case wins that we're actually obtaining in court every single day. Our most popular category of wins this year was fraud. And it was throughout the whole firm, we obtained a lot of wins on fraud. Zaria and Ethan, Natalia, Danielle, Christine Rosales, who just posts one every month, it seems. Alexis, Cintron, and Megan, Nick, and Rasheen, Christian, and Taylor, Matt Shrieks, and Kayla all posted wins. And by the way, if you haven't posted your wins or told us about them so we can put them on the website, like please do, because I love posting wins. And by the way, clients love reading about them as well. That's by far our most popular category. If you look at the number of clicks we get on our website and our social media posts, it's all on these fraud cases, which is, by the way, a big theme that I'm going to be talking about today. We've also had some great wins on appeals, particularly appeals that Misha and Addison handled this year. Our wackiest win, I think, was Misha's win, where the claimant brought in 2,300 job searches that he allegedly did. And the judge threw out the case and was like, obviously, this is ridiculous. You didn't apply for 2,300 open positions. You're not qualified for them. That's obviously ridiculous. It was kind of a fun decision to read this year. Our winningest attorney by far, Christine Rosales. And I know you're saying, Greg, that's not fair. She represents New York State, so she has 1,000 cases to defend. But she's also someone out that I hold out as a great role model for winning and talking about these wins. I know it jazzes me up. I hope it jazzes you guys up to read about them. She had 10 published wins by herself this year and counting, by the way, because I think she submitted 2 more for December that we just haven't posted yet, so they're still out there. She won on fraud 4 times, no employer-employer relationship twice, labor market attachment, permanency, lack of accident 3 different times. So winning on all different issues, not just fraud. And if you're out there saying, hey, I had a lot of wins, I just didn't email Addison and John, please do, because we want to put those up on our website, and it really is something that clients love to see. The trends I saw, when you look at all the case wins that we published, 47 wins published, about 30% of them were on fraud decisions, 16 fraud wins overall. We had 6 wins in occupational exposure claims, and that's everything from like carpal tunnel cases. Olivia had 2 hearing loss occupational exposure cases that we won on, 5 labor market attachment wins, 5 no accident wins, meaning we proved the accident never occurred at all, right? So we're winning in lots of different categories, and a lot of my presentation today is going to be about fraud, but there's a lot of categories we can win in and that we are winning in. And so I would tell you that the trend is, I would tell you 30% of cases winning on fraud, that's pretty good. I think that's pretty high percentage, and it does look like that when it comes in. John would tell you at intake that somewhere around 20% of the cases that come in to 25% are denied at intake. And lack of accident, no proofs, incredible claims, that's a big part of that. Those are the cases we want to get sustained at trial and get those wins. We had a couple statutory changes this year, nothing really major. A lot of board bulletins, they went wild this year with changing lots of little rules, right? Everything from what they're going to approve. Declan and I were just talking about the language that they're approving in Section 32s. We were talking about now the board, every indemnity only settlement and every settlement under $10,000, they just want to do a bench approval of those. So if you are subscribing to their bulletins, you're seeing almost every week they're coming out with some new wacky rule that they're going to apply, try to apply. So that's happening. The rates are going to go up. The rates are going to go up. The rates for compensation are pegged to state average weekly wage. The way that's calculated, of course, is a game. They exclude all sorts of job categories from calculating the state average weekly wage. And every year it goes up and up and up. They changed the law a few years ago to change the minimum rate. And on January 1st, we're going to see our minimum rate go up again from $275 a week to $325 a week, right? So that's this January. It will then be stable from January 2025 to June of 2026 when it's going to go up again. And at that point, it'll be 1/5 of the state average weekly wage, or the claimant's wages, whichever is less. So you're going to see your rinky-dink cases, the ones that don't seem to have a lot of value, or cases even at low percentage of disability, their overall exposure to clients' liability is going to continue to increase. So that's something that's going to drive loss in the future. What was the biggest case of 2024? I'm looking around. What was the biggest case of 2024? Tradesman case. That is the biggest case. It's the craziest case. it's now spawning more and more litigation. So let's talk about the biggest case. And I'm also going to talk a little bit about the politics of systemic fraud. Because, again, I used to joke, it isn't a workers' compensation system. It's a retirement system that they mislabeled, right? But now we know what it really is, right? It's just a fraud system, essentially a fraud mill that we're here. We're trying to stem the tide of this fraud. And it's become more and more apparent. And this tradesman's case, in my opinion, really demonstrates what it is that we're doing and trying to protect employers from. This is organized crime, okay? This is as bad as it gets. The tradesman's case, and we talked about this together in September, was filed by this small insurance company called Tradesman, who started to look, they were writing policies in New York, and they said, wait a second, how come our losses are going up so high? You know, we went from losing a few $1 million a year to over a 3-year period, we lost $110 million. So this is crazy. And they all seem to be related to these like little construction site accidents that are blowing up into these giant losses. So they start looking into what's happening there. And it's interesting from the perspective of tradesmen's an outside player, right? They're not a big carrier. They're not used to New York. They're not used to systemic fraud. They're not used to the courts looking the other way. They're not used to doctors and attorneys colluding to come up with fake cases. So they're sitting out there and they're writing these policies in New York, and they're starting to feel like they're really getting taken advantage of. And they started to look around and say, hey, we need someone to step up and protect us. And they found a law firm in Texas to bring a lawsuit here in New York against the attorneys and the medical providers. And I want you to think about that for a second. I mean, they had to go outside of New York to find a law firm that would even take this case to bring it and to bring it forward. And I think that kind of tells you a little bit about the atmosphere that we're litigating in. The tradesman argument is that medical providers, so the doctors and the medical facilities, and the attorneys are colluding together to come up with fake claims or to overtreat, over-provide medical, bill the insurance companies way too much money. And they're using modern twists on runners to recruit or wholly fabricate injury victims. They actually allege that these victims don't even know that they're being used as a plaintiff in a lawsuit sometimes. They did things like trace how many of these alleged injury victims live in the same house. And they found that in some instances, dozens and dozens of them had the exact same address, which makes them be very questionable. So far, there's 39 medical defendants that are in the tradesman case. And the list here is super tiny. I know you can't read it from the back. But you know, if you see some of the doctors that you know, look, whenever I see a case now that says Surgicare, Surgicore, I'm like, there's fraud. That's got to be fraud, right? That's what they're known for. That's what they've been doing, okay? This isn't libelous. This is all out there. And some of the physicians that we see in our cases on a daily basis are involved in this. So there's 39 medical defendants. But this case goes beyond just accusing the medical providers. It's going into also accusing the attorneys. Right now in our workers' comp cases, we are cross-examining these same doctors, these same facilities. We are challenging their billing. And we're seeing it actually in New York and New Jersey. I can't tell you how many medical provider claims I'm defending in New Jersey that are related to a New York workers' compensation loss where the treatment took place in New Jersey. And they do this on purpose so they can go to a state that doesn't have a medical fee schedule so they can bill even more against the insurance companies. When you cross-examine these doctors, it's valid to ask them, are you a defendant in a lawsuit that accuses you of fabricating and colluding in false claims? Those are fine questions to ask. So far, some of the doctors have started to turn on each other, and there's more and more evidence coming forward that there is definitely collusion between them and the attorneys. But the other interesting thing about the tradesman case is they accused both lawyers and some other organizations of participating in this fraud, and in fact, creating the fraud, and in fact, developing the allegations against the alleged employers or defendants. Subin and Subin, also known as Subin and Associates, Fogelgaren, I mean, we have got hundreds of cases probably with those law firms. Each individual member of the law firm has been separately named, Goriev and Associates. And what they're saying is these law firms worked with and recruited doctors to be part of this scheme. And they also utilized outside sources to develop a funnel or a pipeline of false claimants to come into their offices and signed complaints, or maybe they didn't even come to the office. Maybe the runner threatened them until they signed a complaint, and then they went and filed all these complaints. And so it looks like they're using ex-police officers, hired investigators as runners to go generate claims or teach people how to file these false claims. And they're using social clubs, often preying upon immigrants, recent immigrants, to utilize them in these fraud schemes. So that's what's been going on. This has been unfolding. So this lawsuit was filed in March, and it just keeps getting bigger and bigger and bigger and bigger. And now more insurance companies are now filing on follow-on lawsuits. So there's copycat lawsuits. What they're discovering is these accidents are wholly made up. Now, the interesting part is they have not named the claimants or plaintiffs in those actions as defendants, because they're using those claimants and defendants to flip against their attorneys and to flip against their medical providers to demonstrate that these large-scale frauds are taking place, and they're organized frauds. This is collusive frauds. They were also discovering that some of the surgeries that the doctors allegedly performed were actually never performed at all. They're doing post-surgical MRIs and discovering, wait a second, this treatment was actually the surgery you claim you performed. You didn't actually do it. You just charged us for a surgery. There's another case that's going on right now where a litigation funding company was found to admitted to paying direct money to claimants per medical treatment that they were receiving to try to, again, gin up these fake cases. The current status of these cases is the lawyers that represent the claimants in both the civil actions and the workers' compensation actions are trying to withdraw or drop the cases en masse. In fact, one of the law firms tried to drop themselves out of 300 pending lawsuits at once, saying they had questions about the validity of those claims. Well, you probably should have had questioned your claim before you filed it. We see in our workers' compensation courts counsel dropping out on a case-by-case basis. You've seen substitutions, withdrawals. They're trying to drop cases where they think, wait a second, this one's tainted, this one has some fraud in it. Most recently, so 2 weeks ago, a new insurance carrier filed another lawsuit. It's a copycat lawsuit. It looks like the tradesman complaint. It was filed by a reinsurance carrier. So what's reinsurance? That's an insurance carrier that's going to insure above the risk of the primary insurance carrier. So here comes Ionian Reinsurance Company saying, wait a second, we've been defrauded. We've read the complaint in tradesman, and the same thing happened to us. In fact, they said in a 2 or 3 year period, we had a 484% increase in claims and loss paid in New York in these construction site accidents. So they said, wait a second, this doesn't make any sense. And that claim, they are now naming even more law firms. Well, Subin and Associates is always involved in all of them, so they're defended in that case as well. But now they've named Wingate, Rosati, Shapiro, Moses, and Halperin, and Williams, Switzer, and Associates. So if you do any cases that involve construction law, you've seen those names before, okay? So this is expanding, and there are more and more of these lawsuits that are going to develop. So this is the big deal. I mean, this is like a wake-up call. We've been sort of saying it on a case-by-case basis for a long time. Hey, there's a lot of fraud, waste, and abuse in this system. This fraud that we see in our cases that we're defending our employers against, it's now coming more and more to light. And to me, this is the most important and interesting thing that we could talk about this year. This is wholly unexpected, and it's kind of exciting to see how this develops. I can tell you that when I go and visit with clients, like we talk about what's going on in these tradesman cases and now the progeny of tradesmen. And you know, the shocking thing is that this has been normal in New York for a long time. This behavior has been sort of accepted, or this is how it's been just sort of handled. But how normal is it really? And does the board even care at all? Does the board care, right? Because if we're sitting here talking about it, and by the way, you know all the plaintiffs and claimants workers' comp firms are sitting around here talking about this, and they're worried about it, and they're concerned. Does the board care? So I thought that was an interesting thing to go explore. And the board, the Workers' Compensation Board, has an annual conference every year in Albany. And they bring in the law judges, and they bring in all the senior leadership of the Workers' Compensation Board, which, by the way, employs 1,500 people, right? You know, how you call the board and they won't give you their last name, and you know, it's because there's 1,500 employees of the Workers' Compensation Board. It's huge. It's the second biggest workers' compensation system in the country after California. So you'd think they would care about this. this. Like, it's in the newspaper, it's on TV. You'd think they'd care, and you think it would be a subject at least that they talked about in their annual conference, which is supposed to be talking about what are the big issues facing the board, facing claimants, facing employers in New York workers' comp cases. Well, they did have a conference in October, and I can tell you they did not at all address tradesmen and these new pending suits at all. Now, they did have a presentation on fraud at that conference. But in that presentation on fraud, there's only one slide talking about fraud, and it was about employer fraud, okay? Employer fraud and how to report employers who are committing non-compliance with workers' compensation law fraud. It's insane, right? Like, that's completely upside down and crazy, right? So we're going to see this again. I think it's going to continue to develop over the course of next year, and I think 2025, this is going to be the big theme. Now, we're still on the subject of fraud, so I do want to talk about one other case that I came across recently that's pretty interesting on fraud. So when we're defending a case and we think there's fraud, and we go and get video of the claimant, it's a typical tactic that we deploy. Covert surveillance. Let's do some observations while the claimant's not paying attention, doesn't think that we're watching them. Let's see what they're really up to, right? We love to watch those videos. Who loves to watch those videos? Yeah, nobody, right? Because it's 99% of the time, what is the claimant doing in the video? Not much, right? They're walking around, they go to the corner store, they buy a pack of cigarettes. It's boring, right? I mean, come on, guys, it's billable, right? Okay, it's billable, but it's not usually that compelling. I would tell you 95% of the video I watch is not a slam dunk. It's not amazing, powerful video. 5% of it wins the case. 95% of the time, I'm like, really? All you got them doing was driving around a little bit or maybe going to the store. So this case is interesting, this Gristedes food case. It was decided in September. It's an appellate decision. And the defendant in this case had a lot of concerns about the credibility of the claimant. They got high numbers from their own defense IMEs. They got a 75 from Lager, and they got a 50% from Christopher Smith. We know Lager, but we don't know Smith. I don't know Smith. Does anybody use Smith? Okay, don't, because 50% is a high number, right? So they come up with these high degrees of medical impairment. And so it does look like, okay, maybe they have a valid case. And then they catch the claimant going about his day. On one of the 7 months of video, he goes to Home Depot for the day, and they shows him carrying bags of soil, like topsoil, loading them into his truck during the day. And then he drives home, and I guess he spreads the topsoil, etc. So the carrier or the employer raises fraud, and he says, no, I was within my lifting restriction carrying those bags of topsoil. He says, because they were really light. There was light bags of topsoil. And the law judge actually agreed and said, well, you didn't have your investigator go back and weigh those individual bags of topsoil. And so, yeah, they looked like big, heavy bags, but they could have been light. And so for that reason, I'm going to find the claimant credible. He's not a fraud. Okay. And I was reading that decision, and I'm like, yeah, that is the next level. We don't really do that. So the next time you have a case where the claimant's lifting things, going about their day, I think it's okay if you want to give the instruction to the surveillance investigator to say, hey, at the end of the day, after you capture them carrying those bags of soil, or what do we typically see them doing, right? They go food shopping, carrying grocery bags. I think it's okay if you want to give the instruction to your investigator, hey, go back and take photos at least of those bags of topsoil so we could see they said 40-pound bag, 50-pound bag, right? So that we would have some sort of very specific evidence that we could demonstrate. So the claimant can't come into court and go, yeah, you did see me doing all these things that are outside of my restrictions and that your own doctors say I can't do, but there was really light stuff, or those were empty boxes. Could we go back there and get that evidence? So unfortunately, this case did not go well for the employer, but if they had done just a little bit more, I think they could have won their case. And I think that's something that maybe we could use as one to grow on. So my predictions for 2025. First, I want to thank Addison, Jeremy, Tim, Christian, and Judy. You guys sat with me. We vetted out some of the new technology that LexisNexis is developing, the AI technology, and you also sat with us through the co-counsel demonstration, although it was more a demonstration of what co-counsel won't do than what it would do, right? I got everybody who helped with that, right? I think so, pretty much, yeah. All right, so I think the next thing, or the thing that's interesting to me anyway, is going to be the use of AI in our practice and the use of these large language models and how they're going to help us. Over the course of the last year, we've been comparing all the competing systems. Grok, ChatGPT, that's what I call ChatGPT, Copilot, which is just a steaming pile of garbage, and then the two specific ones which are designed for litigators. So that would be the Lexis AI system. We piloted that, and we also went to a demonstration, right, guys, of co-counsel and observed what it wouldn't do. So it was interesting to see what it could and could not do. And I put some pictures of some technology flops up here. So if you're not a old person like me, that's a Microsoft Zune. That was going to kill the iPod. Google Glass was going to kill everything, and everybody was going to be riding around in Segways at some point. And I feel like we hear a lot about AI like all the time. And I think it's going to be important. I don't know how relevant it is to us just yet. We've been trying to utilize all these systems and try to do it in a controlled way. So particularly with Grok and ChatGPT and Copilot, which are really the three major ones that you can pay for and utilize and test. We've been giving them controlled tests. And I've been doing these controlled tests now for about a year. And in June, I gave a presentation to the New York State Insurance Association, and I did live demonstrations on stage for them of what these systems can do and what they can't do, okay? And to me, the interesting questions are really two questions. Can you answer a question about risk transfer? And two, can you do a calculation for permanency, right? So can you do a scheduled loss of use calculation for me based on a range of motion finding? And the interesting moment is that back in June, everything failed. So if you went to ChatGPT and you said, the claimant has a loss of range of motion of 90 degrees in their right shoulder, what is the correct scheduled loss of use according to the 2018 disability duration guidelines? Okay, that's a plain language query, plain language prompt, and we know what the answer to it. The answer is it's a 40% scheduled loss of use. That's what the disability duration guidelines say. Every single system failed through June, through July, through August. And again, we keep asking them the same questions over and over again to see if they're getting better. In October, they released ChatGPT 4.0 Turbo, and now it can correctly answer that question. So it can correctly, if you give it a plain language query, it is the only system that can give you what is the actual scheduled loss of use. Okay, so that's one that's developing and getting better. The other questions I give it are typical risk transfer questions. We paid out $150,000 in the comp case. The third party case settled for $1 million. What is my client's right of reimbursement? Apply Section 29 in New York. To date, no system will get that answer for you correct, not even close. And when I do New Jersey questions, by the way, where the statute's actually simpler than the one in New York, it gets even wildly wronger. Okay, so right now they're not quite yet ready for it yet. And I can also tell you Lexis failed in 50% of their questions that we asked it. Addison came up with a question asking about successive occupational cases and how those would be calculated. I think Lexis got it correct, did it? And co-counsel wouldn't even answer, okay? And all the other systems got it wrong. So this stuff is still, I would tell you, too unreliable to utilize. And again, we've been giving them the same questions over and over again to try to see what systems we could rely on to give us those kinds of calculations or those types of substitutes for an attorney's judgment. And at this point, nothing. So your jobs are 100% safe. No worries about that for next year. Okay, I'm glad to see at least one thumbs up. Now, inside of our systems, we know we don't use any AI in here, so that's all on testbed stuff that we're doing that with. This year, in November 4th, one of our clients, my first client ever, gave us litigation management guidelines detailing how we are allowed to and not allowed to use artificial intelligence inside of our office and when we're defending them in their cases. And essentially what they say is you can use it, but you can't charge us for it because they're litigation management guidelines, of course, so they have to say that. But they also say essentially this is like any other technology. you're still responsible for getting the right answer. It is not a substitute for your judgment. And I included in this presentation the actual clips out of the first litigation management guidelines I've got there. So still, there's nothing out there that we're going to be able to delegate the type of judgment that we're bringing to these cases, or what's the right way to apply a statute to a specific set of facts. Nothing reliable. I don't see it changing in the very short-term foreseeable future. And the systems that are touted as the most well-trained on legal documents, which is Westlaw and the Lexis system, actually failed worse than commercially available, over-the-counter, off-the-shelf systems like ChatGPT. Again, we shouldn't be using it. It's not there yet. We can't delegate that type of work to it. However, what I do expect is over time we will be able to delegate some of our chores to ChatGPT. Great at summarizing, great at taking long documents and pulling out the 2 or 3 important sentences that you need. It's going to be great for maybe deposition summarization once it's trustworthy and once we can run it on our own metal. Nothing in the cloud, on our own metal, so that we can comply with our cybersecurity requirements. Okay, all right. I also expect this year for us to get way more aggressive on fraud. I think this is going to be the year that more and more fraud gets uncovered, that we're more aggressive with fraud cases, and that we defend more fraud cases. And I also believe the tradesman case is waking up more and more carriers, and we're going to see more and more of these copycat lawsuits, and we're going to see more and more of this stuff come to light. So that's where I think we're going to continue to focus on. Education and CLE is going to continue in 2025. And we have some people that are joining us that are not part of this firm and our clients. So I just want to remind them, going forward, we're still going to be going through the lesson book every month. So we'll be doing our 1-hour CLEs. It's going to be the first Wednesday of the month, just like it's always been. We start over again in our lesson book. Don't worry, I'm going to tweak it to add some new stuff. Okay, keep it fresh, keep it spicy. Our next time we will meet for this CLE will be January 8th, because unless you do want to come in on the first Wednesday of the month, I suspect you don't. Same thing for our New Jersey webinar series. That always follows my practice guide that I write for LexisNexis every year. That will continue, and that will always be the first Monday of the month. Okay, so that doesn't apply to many people in this room. All right, that's my conclusion of our training today. But if I don't see you, have a great holiday season. Merry Christmas. And for clients, I will see you next year.